Hi, good afternoon to all of our followers. My name is Stephanie Matza. I'm an associate attorney here at the law office of Beltran, Brito, Casimir.
I'm Brito, partner at the law firm.
And today we're going to be talking about the category F2A, right? So F2A is a category in the visa bulletin. It applies for individuals who are spouse and children under 21 of permanent residence.
Yes.
Big topic right now.
Well, it's hot topic, Stephanie, really, because currently it is current for the month of July. It is also current for the month of August. Right. This is a very unique thing. By the way, it's current across the board. And what does that mean, current across the board? There's certain countries in the past, such as India, such as Mexico, that has deep retrogression. Right. Retrogression meaning there's too many applicants, the category's over applied. So the line, the waiting time is much longer for these countries and the nationals from these countries. It's current for everybody,
right,
which is a very interesting thing. And it's a very unique thing since we've been practicing, and I've been practicing. It's something that I've really not seen. Typically for most countries and most nationals, you're going to see a wait time of about 2.5 years if you're a green card holder to petition for a spouse, to petition for a child. That's why many of those cases we see them that they are outside of the U.S. The individual that you're petitioning is outside the United States. The difference about being current means if they are here currently in the United States, you could do what's called a concurrent filing. That means you could file the I-130 petition, the family-based petition. That's the individual petitioning the foreign national, and at the same time they could file an I-45 adjustment of status. It is very similar to a process that's called immediate relative when you're married to a United States citizen,
right?
Okay, or your parents are United States citizen, in the sense that it is immediate. You could file stage 1 and stage 2, the I-130 and the I-45, if you're currently legal in the United States. That's the big difference. And Stephanie, talk to me a little bit about what does it mean, the real difference between being married to a United States citizen and being married to a lawful permanent resident for the purposes of this petition.
So if you're married to a lawful permanent resident, in order to be able to get this benefit, you need to have entered the United States legally and have maintained your status throughout this time until you're presenting what we're talking about, which is stage 1 and stage 2 at the exact same time, or stage 2 if you've already filed stage 1, right? Mm-hmm. If you're married to a U.S. citizen, you had to have been entered legally to the United States, but it's okay if you have not maintained your legal status. You may also apply for this immediate relative category.
Sure, that's really the big difference.
Right, the difference when we're deciding on strategy, should you wait until your lawful permanent resident spouse has become a U.S. citizen? It depends. If you have maintained your legal status, the time is now. It is current in July and August. Present your I-45, your stage 2.
It might bounce back in September.
Yeah.
It might, new fiscal year starts October 1st, it might bounce back. So if you've been holding on, if you've been waiting, I don't think it's time to wait. I think it's time to take action.
And one thing, Gil, if you've already presented your I-130 and you had not presented your I-45, you can, even if the I-130 has not been decided, has not been adjudicated, present your I-45 July or August.
That's very true. And as long as the person is currently, when we're talking about an I-45, that's if you're currently in the United States. If you are outside of the United States, what all this means of being current means that you should have a much faster decision, and you should really see cases start to move at the consular level. So this is very good news for all those individuals that are waiting outside the United States. Very soon, the National Visa Center should be in touch with you. Very soon you'll start the processing. And the difference is, if you're here in legal status, work visa, student visa, tourist visa, whatever the legal status is, and you've already had an I-130 previously filed, you could go ahead and file the I-45 as well. And that obviously you could with that either concurrent filing or with later filing the I-45, you're also going to file the I-765 and the I-131, which is the work authorization, which everybody really cares about. It's a very important thing. And obviously the travel authorization. Keep in mind, once you file that adjustment of status, you'll be receiving those benefits in probably in the neighborhood of 5 to 6 months with current processing times, and you may not travel outside the United States if you file the I-45 without the document called the advance parole.
Right.
Okay.
I think that's all the questions we have. If you have any additional questions regarding F2A or any other questions you may have about immigration in general, feel free to comment below. This is our YouTube page, Beltran, Brito, Casimir. You can find us on Instagram and Facebook as well, Beltran, Brito, LLP. Thank you for being with us.